Welcome to the sixth lecture of this lecture series introducing the practice of international arbitration. The last four lectures dealt with pathological arbitration clauses. Like the fifth lecture, this lecture will also deal with strategies to avoid them. As a prelude to this lecture, we look at an interesting article titled A Cautionary Tale, The Perils of Pathological Translation of Arbitration Clauses by Stephan Wilske and Alex Lowe on the subject of translation errors in drafting arbitration agreements. The description and the citation of this article is provided in the references, which is contained in the description below. Those following this lecture would recollect our discussions about the case of the Board of Trustees of Chennai Port Trust versus Chennai Container Terminal Private Limited, reported in MANU TN 0043-2014, where Justice Ramasubramanian, as he was then a judge of the Madras High Court, stated, "The advantage that the English draftsman had was that both contracting parties in England could think in their mother tongue, communicate with each other in their own mother tongue, and enter into a contract in the same tongue in which they thought and spoke. But in India, the situation is completely different. The contracting parties, if hailing from different regions, even within the country, had to go through a thought process in their own mother tongue, translate them into commercial terms in a foreign tongue, namely English, and then have their own communications reduced into writing in English, and that too through a third party." So this really highlights the problems that non-English speaking countries face while drafting contracts and arbitration clauses. We had discussed this decision in the context of translation errors creeping in arbitration agreements. The French case of Séribo versus Hainan, decided by the French Supreme Court and noted in Wilske and Lowe's article, is noteworthy on this point. Briefly, the facts are that Séribo, the French company, agreed to render certain services to the Chinese company Hainan Yangpu, Xindadao. Disputes arose, arbitration was invoked, and an award was passed in favor of Hainan under the aegis of the CIE-TAC, which Hainan sought to enforce in France. The French court held that the same was enforceable, but Séribo appealed to the Supreme Court of France on the ground that the arbitral institution which administered the arbitration, that is CIETAC, the China International Economic and Trade Arbitration Commission, did not have jurisdiction. The Paris Court of Appeal, which first heard the matter, held that the award was enforceable, but on appeal, the Supreme Court overturned the matter and remanded it to the Court of Appeal to consider whether CIETAC was mandated under the arbitration clause to give a final decision, given that no attempt at amicable resolution was made at CIETAC. The arbitration clause was both in Chinese and in English. A comparison of both versions is provided here. The Chinese version said, among other things, in the event of a conflict, the parties will attempt to find an amicable settlement. If this is not possible, the conflict must be first submitted to CIETAC for a decision. The seat of arbitration shall be Beijing. The two parties consent thereto. The matter may be settled by the International Chamber of Commerce. The seat of arbitration shall be Paris. The English version said, the disputes arising over performance of the contract will be settled by amicable arrangement. The disputes that cannot thus be resolved shall be submitted to CIETAC for mediation or arbitration. If it proves impossible to come to an arrangement using the above means, any and all disputes arising from or connected with the present agreement shall be finally resolved in accordance with the rules of conciliation and arbitration of the International Chamber of Commerce by one or more arbitrators appointed in accordance with the said rules. The seat of arbitration shall be Paris. Thus, the Chinese version provided that while disputes are to be submitted to CTAC, the arbitration, if the parties did not have a consensus to refer it to CTAC, the matter would be referred to ICC Paris. But the English version provided that the dispute shall be mandatorily referred to CTAC and the final resolution would be by ICC Paris. The problem was that the Chinese version gave a complete mandate to CTAC while the English version did not. Considerable time and cost might have been expended by both parties only for a court at the stage of enforcement to refuse to enforce the arbitral award. But the lesson that we learn is that even small translation errors can have disastrous consequences. Therefore, whenever the agreement is reduced into two or more languages, the agreement must be looked at preferably by a lawyer having knowledge of both these languages, as language translators may not have the ability to grasp the importance of the legal language. In translation, linguistic accuracy is different from legal accuracy. Another method to minimize the possibility of translation errors is to use the checkbox system or have non-sentential arbitration clauses. Parties need to simply agree on a tabular column in their arbitration agreement. An example is provided here. The table simply says dispute arbitration by CTAC or the institution, number of arbitrators 3, and language of arbitration English. So this clearly conveys the intention of parties to refer their disputes to arbitration by CTAC, and importantly, it is also reduced into writing. Another issue is that the original Chinese version in the Séribo case was itself pathological because it provided for arbitration by two arbitral institutions. The translation augmented the problems further. So, no matter how accurate the translation is, if the original clause itself is defective, an accurate translation would nevertheless be equally, if not more, defective. More on the strategies to avoid pathological clauses in the next lecture. Bye bye.